Jed Wallace has won his case against Blake Lively. So, is there even a smear campaign leg for her to stand on? Let's get into it. Starting off strong, Judge Liman lets Blake know that the court has never, ever recognized a conspiracy-based theory of jurisdiction. He explained that this would violate due process because the amended complaint contained no factual allegations that Wallace defendants directed or controlled any conduct in New York or were aware of any actions that happened in New York or with anyone directed of New York. I love this for Blake. He says, Lively identified 3 separate bases for personal jurisdiction over Wallace. The court agrees with Wallace that Lively has failed to establish personal jurisdiction of any of these 3. I'm telling you, this document just gets better and better. So he goes on to say that this reflects the state's policy of preventing disproportionate restrictions of freedom of expression, and then goes on to say that the court looks to the substance, not merely the name of the claim. Basically letting Blake know, you can say, oh, retaliation. Where's the substance? Where is it? Show it. Well, it's a non-traceable smear campaign. There's no proof anywhere. They got rid of all of it. Literally, Tech 101, they will tell you there is always a trail. There's always a trail. You got nothing. But he calls her out at some point. We'll get to that. He said the court looked for the reality and the essence of the action, not merely its name. He is calling her out. I love this. And this, I feel like this is a really good sign for my sanctions motion, which we should hear by mid-November. So come on. I'm eager to hear too, but this is good. He goes on to say that Lively's response regarding her aiding and abetting claim, like those made in connection with her false light claim, missed the mark. Oh, Blake, you missed the mark. Then he goes on to say, even if Wallace defendants did provide advice, counsel, and strategic assistance to the Wayfair parties, the question remains. Advice, counsel, and strategic counsel regarding what? Blake, what? Then he says, Lively's filings and complaint reasonably suggest its advice regarding publicity, public relations, and shaping public perception. Then he says, Lively's response also falters by focusing exclusively on the activities in question rather than the nature of injury. This is one of my favorite parts. He says, Lively has accordingly failed to carry her burden of establishing personal jurisdiction over Wallace. Unlike many other cases of motion to dismiss stage, there has been extensive discovery in this case to date. Letting Blake know, girl, you have had so much discovery time and you've got nothing. You've got nothing. You failed. Missed the mark. Conspiracy, he said, quote, Lively had alleged insufficient facts to establish personal jurisdiction on a conspiracy theory. Not a smear campaign. Not an untraceable smear campaign. A conspiracy theory. I love this for Blake. I really do. Then he said, this is my number one favorite part. The first step of this test, establishing the existence of a conspiracy. He's going all in. Lively has not sufficiently alleged something more other than publishing a website. She has not alleged, for instance, that the website was prepared, researched, or developed in New York, or that it was specifically designed to target New York residents. To the contrary, she suggests that the website was intended for a national audience and designed to spread a narrative about the lawsuit as broad as possible. The website low level of interactivity also counsels against finding any transaction of businesses. The site merely posts online for public consumption. So again, it's freedom of expression. So again, he reiterates that the heightened standard stems from New York's policy of preventing disproportionate restrictions on freedom of expression, a manner that potentially would chill free speech without an appropriate showing of that they purposely were trying to have a transaction of business here. So he just shows, like, she's got nothing. He states that finding jurisdiction in this case would be inconsistent with the legislature's goal of preventing disproportionate restrictions on freedom of expression. That is because Lively's position requires an expansive interpretation, not only of transacting business, but also of conspiracy jurisdiction. He goes on to say that, nor having any other court for that matter, given that no case has ever applied this kind of conspiracy under this instance. So they're saying like she's basically having them in this gray, like unknown waters. Like this is uncharted territory. No one's had to deal with this. So she's wanting like, we're going to have to make new laws here. Like, let's make something happen for me. He states that finding personal jurisdiction in these circumstances would therefore require not one, but two significant extensions of New York law without direction or guidance from New York courts or the Second Circuit. So that's a no. This next part, I love Judge Liman for. He says, consider a hypothetical scenario. And you tell me if this sounds familiar. For instance, several individuals loosely organize themselves online for the purpose of promoting an issue to the public. Importance, per se, to bring the public and government attention to the alleged defect in a popular consumer product or person. The individuals are scattered across the country, save one that is located in New York. And they research, write, and publish posts for their representative states that are accessible online in New York. It's clear that one, the individual in New York, may be subject to a suit in New York. However, the out-of-state individuals are protected under the CPLR. So, on Lively's expansive theory, I love that, applying the 302 in those circumstances would effectively permit an end run around for the statutory of defamation exception, opening New York courts up to a vast array of out-of-state defendants. So he's just like, girl, you are going to create so many problems. No. Liman states that such an approach would unjustifiably extend the intendment of the legislators to allow, in limited circumstances, to reach the state's jurisdiction beyond its border. Then he says, Lively has therefore also failed to establish personal jurisdiction over Wallace. So because there was no personal jurisdiction, he was basically like, I've got no jurisdiction over this case, so I'm not even going to respond to anything else regarding this. So he concludes that Wallace's motion to dismiss the second amended complaint for the lack of personal jurisdiction is granted. And the second amended complaint is dismissed without prejudice to refiling in a court within the personal jurisdiction. So Blake, if you want to do this, you got to go to a court that's actually in his jurisdiction. Okay. You got to do things the right way. You can't just keep doing all these loopholes. You know what? I got to hand it to Liman. He's a funny guy. That was pretty iconic there. Failed. Expansive theory. First, you got to prove it. What was your favorite part about it? Let me know down below. As always, follow me for more.